I have to assistant counsel.
I'm sorry, who we have here? This is Mr. Griffin.
Anthony, I'm not Mr. I asked for assistant counsel, not counsel.
That's fine.
We'll go on the record in the state of Wisconsin versus Anthony Griffin Jr., case number 25CF939. Could you get the appearances, please?
Assistant District Attorney Jack Schneider for the state of Wisconsin.
And you're Mr. Griffin, is that correct?
No, all statements for the record comes now the living man, Anthony of the Griffin family.
All right, so Mr. Griffin
appearing expressly.
Wait, you need to stop talking. Is Mr. Griffin
appearing expressly
hearing today? Are you Mr. Griffin or not?
I am Anthony of the Griffin family.
Are you the Anthony Griffin that is charged? Stop a second here.
You asked me a question, I'm answering it.
Okay, I don't want you to answer it anymore. I want a yes or no answer to a question, okay? And the question is, and I have to get the case back in front of me, I'm sorry, but bear with me. Lost my calendar. I have a simple question for you.
25CF939.
Are you Anthony Griffin with a date of birth of August 20th, 1985?
I am not the dead entity Anthony Griffin. I am the executor of the estate. I do not agree to be.
All right, well, we'll have to set this over and hold you in custody then until we can have a later
hearing. As I've been held for 72 hours without seeing the judge. That is unlawful.
But you're not Anthony Griffin.
So you are agreeing to violate my common law rights. Is that what you're saying?
I'm asking you to, let's do this, okay.
At this point, it's becoming clear where this hearing is headed. Instead of answering the judge's routine questions, the defendant is laying out arguments commonly associated with the sovereign citizen movement, challenging the court's authority rather than addressing the charges themselves. But here's the key question. Can refusing to recognize a court's jurisdiction actually stop a criminal case from moving forward, or is it simply delaying the inevitable?
I'm going to find probable cause that this is Mr. Griffin that is acting in an obstructing way, but we'll go ahead with it. Do you have a copy of the complaint there in front of you?
I object that you're obstructing my justice.
Your objection is noted.
I'm a more. You haven't.
If you keep talking over me, we're going to cancel this.
Talking over me. I just want to state the facts. Do you not want the facts to be stated on the case? Am I not allowed?
You're not allowed. No, you're not allowed to talk about
an attorney. I am not.
Okay, let's hold him in custody or canceling this hearing. You're going to have to be held. You're not willing to cooperate. Make a record to show that you're violating my rights.
Let the
record note that he refused to cooperate so that an initial hearing could be conducted. That's 25CF939 appearances.
ADA Assistant Marco for the state.
Understand where the defendant's office refers to Mr. Griffin has indicated that he wants to take care of his own case. Right?
Is that right, Mr. Griffin?
No, I'm not Mr. Griffin. I'm Anthony of the Griffin. I am the power of attorney for him. I do not have a question for the court. Will I be allowed to speak freely, or will my civil rights be again granted over?
Oh, you're going to make a statement on bail, but we're going to do this in an orderly fashion. But you're indicating that you're not Mr. Griffin, or that's just not how you identify yourself?
It's not about me identifying myself. Anthony Griffin, there's my all caps entity, which is a dead entity. I actually have an EIN for this created entity. This is not me. I also do not live this address. I'm also not a black man. I am on board. So a lot of things on here are totally wrong, which not be at all. My weight is not 240 pounds. All this information is false. But as for the record.
And here's the first major turning point. The judge doesn't debate every legal citation or constitutional reference. Instead, he makes a direct ruling. The motion to dismiss is denied, and the court confirms it is jurisdiction. That's a common judicial approach. Courts generally decide jurisdiction themselves rather than allowing a defendant to opt out. Do you think the judge handled that exchange calmly, or should he have responded differently?
Record. All statements for the record comes now the living man Anthony of the Griffin family. Jury jurors appropriate persona status appearing expressly to continue to rigorous reporting. I'm not to be mistaken with the all caps state, as I am the occupant executive office and also the sole beneficiary of the state. I filed my power of attorney with the court, and I'm ready to proceed. Let the record show that I do not agree to be a surety for the debt entity as it was created from the state and was given to me and is not a representation of me. I am not one who owes debt to the United States or to the state of Wisconsin. Further, I'm not a flight risk. The only reason I missed court was due to the failure of the court to notify me of said date. Furthermore, upon being detained, I made it very clear to Officer Gilson that I wanted my rights read to me. Officer Gilson first refused after we asked him twice more than he read me my rights. After Officer Gilson read me my rights, I made it very clear to him that I wanted my attorney present with the sheriff. Officer Gilson then replied, "They won't come." I made it very clear to him that if he continued to talk to me without my attorney present and the sheriff present, it would be a violation of my civil rights and my constitutional rights. He ignored these facts and continued with the arrest as a violation of my law and the rights and the protocol that he agreed to follow as an officer. I was pulled over while traveling in a private automobile. The plates read, DOT exempt, do not detain private traveler. I made it very clear to him that he does not have jurisdiction, but yet he forced it. I was never properly identified as a suspect. My fingerprints were taken under direct arrest of origin after I told them I did not want my fingerprints or people taken until I have a court order from the judge. I do not argue with any of the facts in this charging instance. This is not me taking a plea. This is accepted for value and returned for value. All the charges entities in this case, and use my exemption for discharge and set off and release the order to me immediately.
Even though the courtroom exchange has been tense, notice what actually happened procedurally. Bond remains in place. No attorney is appointed because none was requested, and the case is simply scheduled for another hearing. In other words, despite all the objections, the legal process keeps moving exactly as planned. That's often how these hearings unfold.
Okay. Well, I think there's at least a reasonable inference on the record that the person known as Anthony Griffin is the same individual in front of me. When they call Anthony Griffin's case, he came out of the holding cell. I don't know why he would do that if he's not. I gave you an opportunity to speak. I'm speaking now, sir. You can object. There's no basis for it. I'm looking at the court records. Please don't interrupt. I'm looking at the jail records.
The Trust Act of 1666 says that when somebody claims their estate, you are to relinquish all of the things to them.
I don't know what you're talking about. I've never heard that ever.
That also means that this
you can file your written motions, Mr. Griffin.
Court with jurisdiction, and I challenge jurisdiction under Federal Rule of Procedure 5.1.
It's denied. The booking photo and the Stillman records match this particular individual. I'll find probable cause.
Man can be Lord over his own case.
And where would you like us to send mail, sir?
You already have mail. I'll tell you on file. It's P.O. Box, DeForest, Wisconsin.
Okay.
53532.
Thank you.
And I have a right to be
what's the state's position on bail?
Now the defendant shifts into a much more detailed legal presentation, citing statutes, constitutional provisions, and Supreme Court cases in an effort to challenge nearly every aspect of the prosecution. Whether those citations actually apply is a separate issue, but one thing is certain. She came to court prepared with a lengthy argument. Have you ever seen a defendant present this many legal references during a first appearance?
Thank you, Your Honor. In this case, the state is asking the court to impose $1,000 cash bail with the condition that the defendant be prohibited from possessing any dangerous weapons as defined by the Wisconsin statutes. It's my understanding that the defendant posted $5,000 cash on his current pending felony case and then failed to appear in court. He is alleged to have refused to identify himself and has committed additional crimes while out on cash bail, which is, as we know, a general violation of bond conditions.
I object.
It's our position that
let her finish. We can't have this hearing. We are talking over people. We're trying to record it. What's the basis for the objection?
The basis for the objection is the fact that she has no basis of knowing who I am. I don't know who she is.
All right.
She's not even
the objection is overruled. I ruled it, Mr. Griffin. Let her finish.
As far as that failure to appear, Your Honor, it looks like a bench warrant for a body-only hold was issued on January 27th of this year in pending case 24 CF 907. That warrant was not served until almost 3 months later on the 17th of April this year.
So Your Honor, is it true or not that when somebody has a court date that they have to be served a court date so they know that it's there? Or is it okay to actually set a court date without notifying the defendant or the accused and then locking them up for one?
This is probably the most emotional moment of the hearing. The defendant argues that being labeled a sovereign citizen shows judicial bias and even asks the judge to be disqualified. Claims like this are serious because every defendant is entitled to an impartial judge. But proving actual legal bias requires much more than disagreeing with a courtroom label or ruling.
All right, and I gather you're alleging that Judge Highland did not send notice to you?
No, there's no certified anything there. There's no document or proof of service of anything of that date. I went to every previous court date and I don't skip court date. He didn't show up for the last 3 court dates prior to that, and I actually put in a motion for failure to prosecute. Yet they still moved forward as if nothing was placed in and no one came to court except for me and the prosecutor, and the judge was hiding in the back or whatever the case may be. I filed an abatement just to let them know I'm not the person who they're looking for, but yet I keep getting trampled over in court. My rights keep trampled over in court. You have this person standing to the left of me who knows me not at all, and yet I would like her to take the stand and talk about how she knows me personally, because you cannot be a beneficiary.
Well, we're not going to be doing any of that, Mr. Griffin.
And she is not the state. I know her not. So I don't understand what's going on.
All right, well, it looks like they mailed notice to the address that you had on file at the time.
So
But you're going to have to take that up with Judge Highland. That case is not before me. Looks like he's issued a body-only warrant. You can't get released on that until you have a hearing with Judge Highland in that case. I think given the history, $1,000.
As this hearing comes to a close, none of the requested dismissals or extraordinary remedies are granted. Instead, the judge sets the next court date, leaving every major legal argument for another day. The real battle hasn't happened yet. It will come when these claims are tested under the rules of evidence and criminal procedure. Do you think any of these jurisdictional arguments will succeed at the next hearing? Let us know in the comments.
$1,000 cash bail is necessary. I will set that.
I object. It's clear that
And that's fine.
rights have been violated and you're still moving forward. This is called an obstruction of justice.
Don't
Let the
think
record
your
show
rights have
that.
been violated.
Know everything that I've said.
It's all being recorded, Mr. Griffin.
Bad.
You would have the right to a preliminary hearing in 10 days. Do you want that scheduled?
Well, I don't want to sit in jail any longer.
Okay, well, you're going to have to get a hearing in front of Judge Highland on the other case. Right now, you're not allowed to post any cash bail to get released in that particular case. I don't have any authority to do anything with that.
So if you don't have authority, then
You're going to have to address
I object.
that
If you don't
case
have
with him.
authority to actually set me a bail, you do not have authority over me. Matter of fact, Your Honor, are you responsible for me if something happens to me?
All right, and I'll also order that you not use or possess dangerous weapons as it's defined by the state
Are you
statute.
responsible for that?
And because I haven't heard a response, I don't believe we have a waiver of time limits to set a time for
Are you
preliminary
responsible
hearing.
for me if something happens?
And we are adjourned. Mr.
Okay,
Griffin.
since you're not responsible for me if something happens to me, let the record show that you are not. You are crazy. That's lovely. Bad for the city, never us.